Yes.
May I please, your Lordship, I beg to mention for listing group on IA, Lordship.
When?
Any date, Lordship?
After vacation.
After vacation. Lordship, deeply obliged, Lordship.
Item number 17 and 18, we are making a joint prayer, my lord. Kindly peruse the last order, my lord.
Order will be in, my lord, item number IA in item number 18, my lord.
Well, so what is to be done? What do you all want?
Some time is needed, my lord.
My lord, here what has happened, my lord, the learned court below, without hearing the PP, the case was disposed, my lord.
The entire trial, my lord, sorry for interjecting. The entire trial, and this happened across for all the cases for an extended 1.5 year period.
Yes, my lord.
All the trials were conducted without the public prosecutor. Yes, my lord. So, my lord, in this case, similar matters had already been heard by this honorable court and some orders had been passed. So, on the last occasion, Honorable Justice, my lord, Justice Surana was pleased to direct the learned PP to obtain instruction as to what orders were passed in those cases, my lord. That information, my lord,
My lord, because I don't have the names of those persons where those orders are passed, my lord. So we need.
Anyway, how can a trial continue without the PP?
That was the issue. When we were convicted, my lord, in both in items 17 and 18, and apparently, my lord, in some other cases also.
An honorable court one.
Why do you want to adjourn it? For what purpose?
Because last order, my lord, it was directed to take instruction, my lord.
What instructions?
My lord, kindly peruse the order dated 2011-25.
PCR is here. PCR is here not.
2025. Yes, 228.
228 of 24.
24. That order was passed in that IA, my lord. I have the copy of this order, but
IA which one? 228.
228, my lord.
No, we have got 228 before. There's nothing. There's no order.
Perhaps it was there then, my lord, in the
Main case.
No. How did the trial proceed without the PP? What are the basis? PCR is there. Let us see the PCR. Why do you need to adjourn the matter? I don't understand. Isn't it?
The two different cases, my lord.
Whatever. It's a two different orders. Issue will be the same.
One of the issues, one of the issues, man.
I mean, one of the issues will be the same.
Man.
I mean, the main issue. That is the main issue.
No need ping, ping. Ping, 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 ping.
Cross-examination.
In fact, in the judgment also, it's clear, my lord, from the judgment.
No. Cross-examination is done. No. Cross-examination done. Cross-examination done.
Yes.
Examination is done. First examination was done by the PP. Correct?
My lord, yes, but later, my lord, what has happened, some dispute arose between the court and the PP, my lord.
That is with regard to PWA. Recall of the PWA. That is the. Huh?
Before framing of, after framing of charges, he was not there.
Then who cross-examined the prosecution?
Court
witness?
itself.
That court itself.
And then the examination in chief
Yes.
was done by the.
Yes, cross-examination also.
And-
Cross-examination also done by court.
Is that it's going to be cleared of the judgment, which paragraph is like that?
My lord, will kindly see item number 17, my lord. Item number 17, the judgment.
There is a paper book made.
Paper book is there, my lord.
Uh,
I'll just give the judgment, my lord. Page in item number 17, my lord, page 45 of the paper book, my lord. My lord,
Tara?
my lord, page 45, first page of the judgment, my lord.
Yes.
For the state, my lord, none. Then your lordship will kindly come to page 49, para 2. And my lord, in my case, this case, my lord, from the date of the framing of charge, that is, my lord, I have the dates, my lord. The PP had already been debarred from appearing in his court, my lord. So from the date of framing of the charge till the date of the judgment, in this case, my lord, there was no public prosecutor. And this has also been reflected in the multiple orders, my lord. That the PP is not there. So I, as a court is,
Order talking about.
my lord will.
With debarred, order dated.
Well, there is an additional affidavit in all these cases, my lord, in both the cases.
So it has to be reflected in the order passed by the court, na, in the trial court.
Yes, my lord. My lord will,
Court order
Huh?
is there.
Huh?
trial court orders, it is there, my lord.
Wait, what order is before us? Which order dated? Before charge sheet, before charge.
My lord will kindly have the appeal memo in item number 17, my lord. I have given all the orders, my lord.
You just tell us the date. We'll look
Right.
out here. Oh, we'll look out here. This is the order.
On 25/2/2022, my lord.
It is criminal appeal,
52.
In section case, which one?
Sessions case number, my lord.
22, 21.
Special POXO case number 5 of 20. That is perhaps your lordship is looking at item 18, my lord.
In that case also order dated 22/2/2022. 2022.
No, where is the order barring the PP to appear? There's no order barring the PP.
No, that is not the part of the record. When this court lordship directed the LR to submit a report regarding this. And on that aspect, this was informed to this court that there was a direction from the district judge that you hand over the case direction.
Direction or written direction?
That
That is what we want to know. We thought it was a written direction.
An affidavit has been. The lordship will have that affidavit.
Leaving all those issues aside,
Yes.
can a trial be conducted without the PP?
Going to be decided.
That is the only issue. Yes, can it be conducted?
no.
No,
it
ma'am.
was-
Sure. Why? Supposing the PP does not want to appear, then can the court be held to ransom?
So stay.
Well, there is a compilation of judgments I have given in item number 17, my lord, on this issue, my lord, which your lordship will find in both the records, my lord. Because my IA was heard on this issue, my lord, and the IA was allowed primarily on this aspect.
I was allowed
I was-
for suspension of sentence.
Suspension of sentence, my lord. One of the grounds.
Tail Singh, listen,
General Singh, my lord, will kindly come to
have you got?
Yes.
page 30, my lord.
Page 30.
Page 30 of that compilation, my lord.
Yes.
Relevant portion, your lordship will find at page 33, my lord.
Yes.
Para 9, my lord. This is a Privy Council judgment because there is no Supreme Court judgment on this. So Privy Council and multiple High Court judgments. Para 9, if your lordship will kindly have.
Yes, yes, please read.
The absence of a prosecutor necessarily invoked a breach of section 226 of the ordinance.
Which is the ordinance? Which ordinance?
Well, this was regarding, my lord. Because this was a Privy Council judgment, my lord. So there was an ordinance of the administration of that your lordship will find it para 4. Administration of Criminal Justice Ordinance of 1926, my lord. That criminal procedure prescribed, my lord, in that time, my lord. This is the first judgment. On this judgment, my lord, there are multiple High Court judgments. I'll come to all of those, my lord.
Para?
The ordinance, my lord.
Yes.
Para 4, my lord. This provision is exactly the same as 225 of the CRPC, my lord.
Give me to CRPC. Okay. So we read
My lord.
para
9, my lord.
9. Two 25.
May I continue, my lord? The absence of a prosecutor necessarily involved a breach of section 226 of the ordinance, since he could neither open his case nor examine his witnesses. It is to be observed, however, that the definition of public prosecutor in the ordinance completes that there may be a prosecutor other than a public prosecutor regularly appointed by the governor under section 356. And their lordships cannot think that there would have been an overwhelming difficulty in securing the services of some suitable person as prosecutor, and thus avoiding the acquittal of the accused for lack of evidence tendered against them. The course was not followed, and the judge himself undertook the duties of the prosecution. That was the real vice in the trial. Breaches of particular provisions of the ordinance might have been cured under section 393, but the combination in one person of the duties of the prosecutor and judge in their lordship's view prevented the trial from being one conducted substantially in the manner required by the ordinance. The accused did not have the protection to which they were entitled under the ordinance, namely to be tried by a judge whose mind was not and could not have been affected by assuming the duties of a prosecutor. The curative provisions of section 393 of the ordinance, which is expressly in substantially the same terms as section 537 Indian Criminal Procedure Code, cannot be called in aid to support a trial conducted in a manner substantially different from the law from that laid down in the ordinance. So in so judgment, their lordships have no doubt that the trial judge did his best to be scrupulously fair to the accused, but it is impossible to be sure that a judge who himself examines the prosecution witnesses escapes an unconscious bias in favor of accepting their evidence. The judge rightly refrained from cross-examining the defense witnesses, but it would be difficult for him unconsciously to avoid discounting some of their evidence on the ground that it might have assumed a different aspect if subjected to cross-examination. The chance, perhaps a small one, that some witnesses might have impressed their veracity upon the court by the manner in which they stood up to cross-examination was lost to the accused. It has been said many times, it is necessary not only that justice be done, but that it may be seen to be done. The accused and their friends can hardly have felt assured that impartial justice would be meted out to them by a judge who was acting as a prosecutor. And there is another judgment, my lord, by the Honorable Karnataka High Court, that your lordship will find at page 27, my lord.
No, so in this case, the trial judge
Yes, ma'am.
was the prosecutor and the defense lawyer.
No, defense lawyer was there
Huh? In your case, it was.
Prosecutor and judge.
He was the prosecutor.
and the judge. Accused were represented.
Because- But why did he do it?
My lord,
The
my lord, regarding that one affidavit has been filed in item number 18. state.
No, let us go one by one. Let us not mix up.
Well, no,
They are going to
same issue, my lord. Regarding that issue,
same issue.
because
17 and 18 are on the same FIR.
No, my lord.
no,
Same
no, my
fact.
lord. The issue is regarding non-availability of
You-
prosecutor. Yes, ma'am.
But for item 17,
My lord.
was the judge the same?
Yes, my lord.
Yes, ma'am.
17 and 18, the judge was the same.
Like, there is a particular period. In those period, several judgments were filed without the prosecutor.
Any specific reason?
My lord, there was a dispute between the prosecutor and the judge. My lord, he was debarred from entering his court. My
The
lord,
prosecutor.
prosecutor. My lord.
Was there any attempt made by the judge to get another prosecutor?
No,
No.
no, my lord.
And that entire period, there is no.
My lord, my lord, regarding this, that's why I'm placing this affidavit, my lord. That has been explained.
No, let us see the affidavit. Huh?
This fellow attempt that.
Let us do it one at we'll do item 17 first.
My lord.
Which is item 17. It becomes confusing otherwise for us. You all are jumping from one case to the other. Which one should we go into? 17 or 18?
18, my lord, I have this affidavit 18 because the
18.
prosecutor is asking the reason, my lord.
Give
That's
me
why.
18. We'll do 18. 174. Where is 174?
Yeah, my lord.
Yes.
Affidavit page 206, my lord.
Para 3.
Para 3, my lord.
Two zero six.
My lord.
I don't have 20. I've got 203 only.
He is referring to the affidavit. sir.
Affidavit.
Acha. 206.
206, para 3, my lord.
Yes. No, what do you want to show?
My lord, that is the issue. He was, my lord, kindly peruse page
No, that is all right.
215, my lord. That-
215?
Yes, my lord, the annex. Here the PP showed the dispute. Basically, I am showing the dispute why he was debarred, my lord.
Another PP was appointed on 1/6/23.
But prior to that, those evidences were recorded.
Yes, my lord.
In that interregnum period.
Yes, my lord.
No, there's not debarring. There's nothing to show that he was debarred.
There is an official communication which says that all the records were called by the district judge, Lordship. That he was asked to submit all the case diaries.
All right, but you have been saying that the district judge or the session judge depart the PP to appear. Where is that?
That,
The affidavit doesn't say that he was debarred from appearing. He on his own is not appearing because of some issue.
Calling for this
Annex 4, no.
annex of
And anyway, the excuse given by the prosecutor that he has to do the work of the
yes, yes,
clerk,
yes.
typist, that is his problem,
It is-
not the problem of the court.
And
Why
this
should the court solve his problem? Does
And
he
I
want the court to cook his breakfast also?
and annex of 4, my lord. By this letter, all the records were called for from him, my lord.
No, that's
Yes.
you see, but the issue is he did not appear because of the court officer, shouting at him. And his excuse is that he cannot do the work of the peon, typist, because government is not giving him enough facilities. And if he had known about the facilities, he would not have joined. That is the problem of the prosecutor.
Of
No
course, sir.
problem of the court. Only problem is, can a case be decided without a prosecutor?
My humble submission that cannot be.
That is the only issue.
In that case, if prosecutor was not appointing, then Lordship that 24(6) could have been taken recourse to. Section 24(6) CRPC.
You mean assistant public prosecutor?
So that have to be informed to the district magistrate for appointment of public prosecutor immediately, Lordship.
If we put a second.
4 also there, 24(4). And section 225 is very clear that says, Lordship, that the prosecution shall be conducted by a public prosecutor. Shall word is there.
Which one? Where?
Section 225.
That is it.
Just
That's also, what order do you want?
And actually, on last occasion, Honorable Justice Suranath, he observed that he might have done similar cases because he thought that one inquiry was made as per his version, my lord. And if there is any other cases, because in that period, other judgments were also passed, my lord. He wanted to know what happened to those cases, my lord.
Anyway,
so-
at the end of the day,
Yes, my lord.
even if there can be only two outcomes. Either those cases also were completed without any PP,
Yes, my lord.
or they were completed with a PP. That's all.
My lord.
So if they were completed without a PP, then they fall in this category. And if they completed with a PP,
Other category.
then you file an appeal or whatever.
My lord.
So out here, the only issue is whether a criminal case can be disposed of without a PP, and whether the opening itself of the case can be done without a PP. So it cannot be done. So it goes. That's all. what is the point of going into why it was not done or because that would be in a manner that would be more of
Departmental and
pointing towards the administrative side of
Yes.
the issue. No? What is there to be done? We'll dispose it of. The consequence is this, that. Anything else to say?
no, this is the
So we'll send it back. Let it be decided. And let the state appoint a PP. If
No.
the,
Already they are.
there cannot be a bar or the court cannot bar a PP from appearing.
minor.
And there is no order barring a PP from appearing also. There is no order.
Specific.
What?
There's a, in the compilation, my lord, I have given a judgment of the Honorable Karnataka High Court,
Ah,
where the Honorable Karnataka High Court said that in similar circumstances, there was no PP and the trial was conducted, that a retrial cannot be ordered, my lord.
Because already the defense has been disclosed now. And they know what.
no. But then how can it? Huh? I don't think so.
How is-
Well, you mean to say that a retrial cannot be ordered? You go to Supreme Court and challenge that.
I'm just wondering, my lord, there's-
If the opening cannot be done, everything stands vitiated from the time of opening of the case. So why not? Why not? Why not a retrial? We can matter that. Why not? If the judge cannot be a prosecutor and a judge, whatever action he has taken is vitiated. That cannot bar a fresh retrial.
I will just
You can go to Supreme Court and clarify the issue. No bar, you've got that alternative. Let us see your Karnataka High Court judgment.
Lordship will find it at page 27 of the compilation, man. And relevant portion starts from para 3, my lord.
Yes.
Page 28, man. May I read, my lord? 3 to 6, man. We are unable to accept the submissions canvassed by the learned additional SPP who tried to defend the order of the trial court. There are well-defined principles with regard to the conduct of criminal cases, wherein the case for the prosecution is required to be presented by the public prosecutor and the accused is defended by the counsel for the defense. It is the function of the presiding officer to hear the case impartially, and it is a well-defined principle of law that if at any stage the presiding officer does any act which indicates some bias, favoritism, or prejudice is shown towards one of the several parties, then the decision would be vitiated. This is a well-defined principle of procedure based on well-accepted canons of ethics, and it is really the foundation for the confidence that is required to be reposed in the courts. To say that we are not only shocked but distressed would be an understatement, because it is not a question of evidence being recorded, but of the fact that the presiding officer virtually took over the role of the prosecutor, which is a total breach of the canons which we have indicated earlier, and consequently the appeal court was perfectly justified in having set aside the conviction on this ground. On the next question as to whether we should order a retrial, the learned additional SPP submitted that assuming that the earlier trial was vitiated, a retrial is a must, because otherwise the accused technically gets away after having committed an offense of some seriousness. We have perused the records very carefully, and we do not share the view that the incident was one of seriousness. The injuries caused themselves were relatively minor.
It is different.
But I'll come to facts, my lord. Just your lordship will kindly just bear with me.
See, we have perused the records very carefully and we do not share the view that the incident was one of seriousness. The injuries caused themselves were relatively minor, which is why the trial court on the earlier occasion awarded a very light sentence. So,
Then the next question, kindly.
the next, okay, read.
The more important aspect is that the learned advocate who represents the accused points out that he is a person of very modest means. He is present in court and he informs us that he works as an agricultural laborer. The incident is of the year 1995. It took place on 3/10/1995 to be exact. Almost 8 years have elapsed now, and we find on the present record that the state, which is also responsible for the trial getting vitiated on the earlier occasion, has now come forward with a plea that the retrial be ordered. Respondent's learned advocate makes a strong plea to the court that no such retrial be ordered, principally on the ground that it would be harsh to the accused because the accused has already undergone through the ordeal, not only of a minor offense.
Yeah, minor offense, that's why. This is a serious offense. This is the issue of murder.
His case model, my case of Poco, my lord.
So those are according to you minor.
No, no, not at all, my lord. Not at all. I was submitting on the principle, my lord. That
Ah.
I was only submitting on the principle.
The principle laid down by the Karnataka High Court with regard to minor cases, not serious cases.
Only the last line, if your lordship will kindly bear with me,
Yes,
only the
yes.
last line.
Yes.
The state was duty bound to have ensured that the prosecutor was appointed in the trial court, and if that had not been done, the state cannot be heard to ask for a retrial at this late state of the proceedings.
Out here, the state had appointed the PP. PP was there, but PP did not go for whatever reason, according to you, barred by the court.
He in fact tendered his resignation also, my lord.
Whatever. So, was it the fault of the state? Was the state was knowledge given to the state?
Yes,
That the PP was did not appear and they should appoint a new
He
PP.
submitted his
resignation,
to the LR
LR also, my lord.
already.
And
That was a later issue. Anyway, we do not subscribe to the Karnataka High Court. Unfortunately. Yes. Anything?
My lord, I leave it to your lordship. Otherwise, my lord, it cannot be.
So we are our view is that we should go back for retrial and let the and the court should allow the PP to appeal.
Only thing is that on the last occasion, the honorable court, my lord, here, the opinion was given that my lord might have, my lord, in similar issue, some order was passed here in High Court.
There's no need.
No need to.
Meaning what had happened
Yes, my
on
lord.
earlier occasion.
Okay, okay.
We are changing our minds.
Right.
Assume Justice Surana
Yes,
is me now
Yes.
and the other judge is him.
my lord.
Okay,
My lord.
now you get it.
Right.
We're changing our minds slightly.
My lord.
Is your lordship trying to dispose your lordship can fix it on Friday or any other day?
Why?
Lordship? Your lordship, my humble submission is that today I was under the impression that whether that order will be placed before by him, lordship. So I was not prepared. So and
What is there to prepare?
no, in other words,
You tell us now. You tell us now. The case is,
lordship,
the case pertains to a conviction
lordship,
where the judge acted as a prosecutor
lordship,
and a judge,
lordship.
thereby violating section 225
Lordship.
CRPC.
Right.
So when there is a violation of 225,
Right.
what is the logical conclusion? Can the judgment stand?
No, that cannot be, but only
Can the trial be said to be a proper trial?
no. So,
Then the trial is initiated.
can aspect where if your lordship is remanding back the matter to the trial court,
Yes,
only on
yes,
that aspect, lordship.
It's a very minded.
Right.
How?
Because lordship, this, there are judgment which says lordship for procedural lapses, that case cannot be remanded back. So I will place
So
that.
out here, you see, when the entire thing is vitiated from the very beginning, you know, the evidence cannot be looked into. There's no question. There's no question of making any finding on the basis of the evidence. There's no res judicata type of thing here.
Right.
Right. Item, I will do this. Item 18 first. Heard, Mr.
Yeah.
Hey, Amit. Learned counsel for the appellants who submits that the appellants have been convicted under section
302 with 34
302/34 IPC,
and 324.
read with section
324.
324/34 IPC. Without the trial being conducted by a public prosecutor / public prosecutor, he submits that the opening of the that he submits that from the time of
Framing of charges, 22 to
Framing of charge also he was not there.
No, there.
Okay, so from the time of framing of the charge till conviction of the appellants by the learned trial court. No PP had no PP/APP had appeared. Conduct prosecution on behalf of the state. The trial judge acted as a prosecutor and had taken the evidence of the prosecution witnesses during examination in chief of the witness. He thus submits that the learned trial judge acted as a prosecutor and judge in the case. And as such, the conviction made by the learned trial court should be interfered with. Puska. Next, that's all I think. Na? Mr. KK Kaushik,
Yeah.
the learned APP. On the other hand, submit. No, not on the other hand. The learned APP submits that. He has no quarrel with the submission made by the counsel for the appellant to the effect that that no public prosecutor/APP had conducted the prosecution case before the learned trial. The learned presiding judge had acted as the prosecutor and the judge in the case. In view of the above, the entire criminal trial, including recording of the evidence of the prosecution witnesses, was vitiated. He submits that the same being in violation of section 225 of the CRPC. The impugned judgment should be set aside and a fresh trial, retrial, and a fresh trial, and a retrial, and a retrial should be initiated by the learned trial. We have heard the learned counsels for the party. Section 225 CRPC states as follows. A perusal of the section 225, next paragraph. CRPC shows that in every trial before a court of session, the prosecution is to be conducted by a public prosecutor. The present case being a case, the present case being a murder case. Now, a public prosecutor was necessary to conduct the trial proceeding before the learned trial. However, the same had not been done. The public prosecutor/APP had participated in the trial proceedings from the time of framing of charge under section 302/34 read with section
324, 302,
324/34 IPC. Till conviction of the appellant by way of the impugned judgment dated
Judgment dated 31/2023 and sentence dated
301/2023 passed by the Sessions Judge Chirang Kajal Gaon in Sessions Case number 08/2020. Which is that judgment you were referring to? Page 45. I think.
My lord, we'll find it at page 30, my lord. Privy Council there. Open portion, page 33. Paragraph 9.
Do we have to mention this? No, not required. No. First off. When there has been a breach of section 225 CRPC in conducting in conducting the trial proceeding wherein the learned judge undertook the duties of the prosecution in the absence of any public prosecutor slash APP, comma, the trial proceeding, which included the recording of the evidence of the witnesses, would have to be stated to be vitiated, would have to be deemed to be vitiated. Full stop. The present case being a case relating to murder, which is a very serious case. That could lead to a sentence of life imprisonment or death. We are of the view that the conviction of the appellant by the learned trial court in violation of section 225 CRPC is not sustainable in law. Accordingly, the impugned judgment dated 30/01/23 passed by the learned Sessions Judge Chirag Ajal Gaon in Sessions Case number 8 of 2021. 08/2020 is not sustainable. The same is accordingly set aside. As in view of the above, we are of the view that when there is a when the guilt of whether when the guilt or innocence of the accused has to be decided with respect to very serious and heinous crimes, it would be appropriate for the learned trial court to have a retrial of the case, wherein framing of charge and recording of the evidence of the prosecution witnesses is done. with the, by the prosecutor. And in the presence of the presence of the public prosecutors, that AP. The trial court is accordingly directed to retry the case after restarting the trial from the stage of framing of trial of the appeal. That's all.
The appellants are in custody, Lordship, so they may be directed to be released because during trial they were on bail, Lordship.
That too you go there and ask.
Because already this, they were taken into custody in view of this judgment, Lordship. And that,
You, huh?
they were taken into custody in.
What's the bill there?
Already this judgment is set aside by your Lordship. So if your Lordship do not grant bail, they will remain in custody. Lord.
No. Which,
Because during trial and during at the stage of framing of charge, they were on bail, Lordship.
maybe the appellant's counsel's prayer for bail. Would have to be decided by the learned trial.
Because it may take time, Lordship, the records will go that it may take time.
Send back the LCR this year. The appeal is accordingly. The case is remanded back to the trial and the appeal is accordingly disposed. The appeal is accordingly disposed of by remanding the case back to the learned trial.
Registry may be directed to remand.
The other one,
Registry may be directed to send back the LCR expeditiously.
already done.
Obliged.
You made anything out here, Mr.
S. Nawaz, my lord.
S.
Nawaz.
Nawaz appears for the appellant. While Mr. R. Kaushik, APP appears for the state. Huh? This is an appeal against that impugned judgment dated 24/8/22 passed by the session judge Chirang Tajalgaon.
Very special judge, my lord.
Huh?
Special judgment. Same judge, my lord, but you are acting as a special judge.
By the, it is a session judge. Come to page 45 for the paper.
Yes, my lord. Session judge. my lord.
Session judge.
In some cases, it had
No, you see, there is one thing, I'll just tell you. One thing. You see, sometimes special courts are made.
Yeah.
But in some districts where there are no special court, the session judge have been given the powers of the special.
special judgment. Special.
But then here,
My lord, seal and signature is special judge.
okay, but in the heading is given.
Session judgment. Session judgment.
Seal and signature is special
Okay,
judge.
passed by the session judge / special judge. Sang at Kajalgaon. In special POCSO case number 05 of 2020. Arising out of Daligaon PS case number 196 of 2019, page 45, by which the appellant has been convicted
Under section 376(3)
under section 376(3) IPC
and minus section 6 of the POCSO.
and section 6 of the POCSO. However, sentence has been imposed under
Section 376.
section 376(3) IPC. Out here also from framing of
From
charge,
the framing of charges, madam.
same thing. Okay, we are disposed of.
One place is where your lordship has written PP/APP. Here perhaps it will be special PP, SPP. madam.
Okay.
Waiting for it.
I want to know this.
Miss
Pending.
L. Devi appears for respondent.
In this case, the it is on bill.
It is a bill. Okay, so we don't have to, huh?
Legal granted.
So after you say like, after that, previous thing, the appellate shall continue to be on bail
It's not.
till final, huh? Yes, shall continue to be on bail, huh?
Because I was on bail and this honorable court
Shall
subsequent.
continue to be on bail. Unless, during the trial before during the retrial, before the learned, trial, provided the bail condition are not violated by the appellate.
Deeply agree.
My please, your lordship. Item 20, lordship. Today's list, lordship. We have filed a miscase, lordship, IA, but it has been not numbered. It is on a serial number, lordship.
So what to do?
So, lordship, there will be order made by the registry to number the case, lordship, IA. Because,
First of all, we do not know whether it is under objection.
no. It has been not tagged with the main case, lordship.
Correct, but when did you file?
Lordship, I filed on 19th, lordship. This is the,
Have you go and check it up whether it is under some objection or not?
no, it is, I think, it's okay. I think I'm not anchored. But-
You inquire first.
Then, let it become on some date, lordship, fixed. With,
Okay, right.
because it is not tagged with the file.
Right.
Then
Right, Mr.
G dash for
He
the
asked
appellant.
the counsel for the appellant. Submits that he has submitted the in terms of the last order
Lordship.
on
On 16/12/25, Lordship,
16/12/2020.
25.
However, the same has not been listed today along with the main appeal. List this matter after the who, in the meantime, don't worry. Mr. Jidas, give a date, huh? In the meantime, Mr. Jidas shall verify as to whether the IA filed by him is under objection or not.
Lordship.
If the same is not under objection, the same may be listed on 6/2.
6/2.
And the the filing number being
Filing number, Lordship, it is IS Civil 16614/25. Date of filing is 19/12/25. After 3 days, I
I'll
filed
give
it.
the number slowly.
Yes, Lordship. Let me demo episode later. I will take it afterward.
Okay, next.
Lordship.
May please, your lordship. I beg to mention item number 16, lordship. Lordship, as per office note dated 11/8/23, paper book needs some correction, lordship. So
Oh, not correct.
but it was prepared by not registry. It was prepared by earlier advocate engaged in this case, lordship. So matter may be taken up after vacation, lordship.
Just give us the file, item 16. Where is the order? The- Yes, there is some mistake.
Yes.
Where, which pages?
I don't know, sir, lordship.
And it cannot be like this. You tell us which pages. One comma is missing or one full stop is missing. Where? What is the mistake?
I was not instructed, lordship.
Which court is she in? Which court is your senior in right now?
Senior is, sir, not available today, lordship.
Not available today.
Yes, sir.
What to do? This is But then you see the problem is, then they're asking the appellant.
Errors paper. See that,
Yes, but oh, Deepak, he's the one out. Hello, why is he here? Yes, but- who's the senior?
B Halda Lordship.
The Haldar. Okay, right. Adjournment prayer has been made on behalf of Mr. B. Haldar, learned counsel for the appellant, on the ground that the paper book made by the earlier counsel for the appellant contains some mistake. Accordingly, release this matter after.
Okay.
You would.
We present Lordship, back to mention for listing of criminal appeal for orders, my lords. Any day after vacation. Of lordship.
May I please, your lordship, I beg to mention item 21 and 22, lordship. With the consent of the other side, we want to adjourn the matter, lordship. My senior is out of station for a marriage.
Who's the senior?
MS Chaudhary, lordship. We have taken the consent.
Yes, madam, who is there?
Lordship,
One is criminal appeal for his conviction, one is against technical, right?
Lordship, I am in opposite party in 21, Lordship.
Now, there is a 430 application of.
Oh, shit. Papa Lusamini, consent to Papa Lucina. Okay. They've taken consent from Mr.
All right, I'm asking you, they want adjournment. I'm asking you, where's your affidavit?
Objection.
Yes, objection.
Bulbasaur. Was it Pento? আমি দিয়া নাই তো আমি নাই অবজেক্ট ফাইল বানাই না ফাইলে নাই
You have not filed.
ইনশাআল্লাহ হাসো
How much time do you want?
হিল আছে কোন আনন্দের নাম আছে এখানে সেম চেম্বার নো এটা নাই হতে
Well, immediately after Bihu vacation.
All right, Mr. R.R. Kaushik, learned counsel for the land APP is granted. How much time?
Immediately after Bihu vacation.
Immediately means how much?
Now like
1 week, 10 days?
10 days, my lord, on 22nd.
Okay, is granted 2 weeks time to file an objection. This is the matter on
22nd.
26th.
Lordship, Lordship directly to produce the records, Lordship, but I'm yet to receive the
No,
records. Lordship.
yes, madam, you tell me.
Lordship, the previous order was to produce the records and to seek instructions as
The big
to,
issue is what? Whether they are 3 limbs or 2 limbs.
Lordship, that was supposed to be produced from the record as per the last
No,
order.
no. Supposing there is a wrong understanding by the authority, I mean, a wrong understanding by the authorities, under which limb it can be attacked or it should be attacked. Would that make any difference?
Lordship, but that would be better if it is perused and plus my learned senior had already taken consent that she will be praying for time. So on that particular aspect of the matter, as your Lordship is asking, I will require some time.
See,
to do some research.
because here, I think this 2-1U
2-1 Lordship.
proceeds of a crime means any property derived or obtained directly or indirectly by any person as a result of a criminal activity relating to a scheduled offense. Correct?
Lordship.
Now that is the first slip. Any property obtained.
Yes, Lordship.
Number 2 is value of such property or where such property is held taken outside the country.
Then the property equivalent in value held within the country or abroad.
Then the pro-
Instant case, Lordship, the entire facts of the case, the petitioner's case
case is that you had bought the property prior to the scheduled offense.
prior to the scheduled offense.
The issue is when the property cannot be traced up after the scheduled offense,
Lordship, is noted
Then
in the findings.
can't that relate back to any other property which may not be the proceeds of a crime?
Lordship, but there has to be a nexus between the two. The nexus and the reason to believe as to why this particular order is being passed or why this particular property is being attached.
But what about
That
that
needs to be satisfied.
Vijay Madan Lal Chaudhary's case?
I'll have to check that up.
This is the entire issue. Vijay Madan Lal's case does not seem to be in your favor. Because as per Vijay Madan Lal's, when you read 21V, 21V prima facie appears to show that there are only two limbs. But Madan Lal
Lordship,
Chaudhary's
the
case,
explanation, the explanation takes it to the third link.
correct, then
But Lordship, the nexus and the reason to believe that this particular person is involved and there is a requirement to attach the property. There has to be a reason that needs to be assigned by the adjudicating authority. So in the instant case, there is no reason as such. The reason to believe is
no, but then you have already, it has been determined that out of the 6 crores, you have been given 40 lakh.
no, Lordship. That has not yet been proved. That is just an assumption.
But that, now the thing is that assumption that this attachment cannot be done prior to proving the issue. That's your case.
Lordship. So
I don't think that is the case.
the reason to believe has to be there.
Proceeds of a crime doesn't, you see, it is to ensure that at the time of delivery of judgment, the property is there already, so that it can be recovered straightly.
But Lordship, even if we go by that angle, the proceeds of the property which has been attached is not equivalent in value to the
In
amount.
fact, this is less. The amount that they've attached is less.
Lordship, that is what the provision clearly says. Then the property equivalent in value
No.
held within the country or abroad.
Correct. Equivalent. Maybe equivalent. But then the thing is that supposing they can identify a property which is less than the amount which you have than the offense, than the value of the offense. Supposing the proceeds of the crime amounts to say 40 lakhs, as in your case. But they can only identify properties of 2 lakhs. So they are going to say better at least 2 lakhs instead of 0.
Lordship, my humble prayer would be like at least let the respondents produce the records and on the basis of what the order has been passed. Under what
Actually, that was not even required.
Lordship, that was the last order of this honorable court.
Not even required.
Order clearly
What do you say?
says
Yes, please. Maybe why you not bringing the file? There's the small thing actually
Lordship, I have intimated the office day required, so
huh?
by another 2 weeks,
You,
Lordship.
you get it.
I will get it, Lordship.
Well, information.
I will get Lordship.
And we don't even need that file actually.
Yes, sir, but because there was a direction, Lordship, so
You bring that file.
yes, Lordship,
Okay.
I'll get it, Lordship.
Then council for the respondent,
Yes, Lordship.
for the enforcement directive.
Yes, Lordship.
That means that she will produce the concern records on the next day. List the matter on give it.
Deeply obliged.
May I please, your lordship? Lordship, in this case, lordship, paper book prepared, lordship, but not served to us, lordship. Paper book prepared, lordship, but not served to us, lordship. May I pray, lordship, may please?
Paper book, give it. WO file 302.
Lordship,
Any witnesses?
lordship may fix day after tomorrow, lordship. It will better to Friday, lordship, or tomorrow, lordship. For consideration of IA, lordship.
Okay, after. You're giving a copy next.
Lordship,
Mr. A.
Ayu Chaudhary.
Mr. Ayush Chaudhary, learned counsel for the appellant. Applicant applicant. Been provided a copy of the paper book today in court. It is also noticed that written objection has been filed by the state in response to the application under section 430 BNH. On the prayer of Mr. Ayush Chaudhary, this is the matter after the Bihu vacation.
Each day date, lordship, after.
Give it.
Deeply obliged.
I'm sorry, Lordship, in this case, I am appearing on behalf of S.
Okay, right. As paper book has arrived, no, as TCR has arrived, registry to prepare the paper book. Huh. Then what about notice?
Service complete, my lord.
Where is that?
My lord, we have received one letter from the police officer. Template.
Give it to us.
My lord.
Mr. R. Kaushik has submitted.
Motion you received. Yes.
Where is it? No, this is-
Ajara PS, ইয়াতে দিয়া আমাকো দিছে।
Where is the letter? Submitted a letter dated. No. What is the date?
6/1/2026. আমিনুল
No, this.
কি হয়? কি মানে?
Aminul.
আমিনুল তো?
Aminul.
Submitted letter dated what?
6/1/26.
Where is
Because
that?
IO here দিয়া নাই নেকি কপি বিলাক?
What you are giving us? You all are giving us documents.
এইখন আমিনুল আলী সেম নহয় নেকি? জাস্টিস সাইকিয়া ফরওয়ার্ডিং ফর্ম। Yes. Yes.
No, you see,
Report
we
will
want a
submit
report
a
from the OC saying that notice has been served.
Yes, it's there and closed here with there with. No, what they have done, they have sent one letter report to the office concern. Yesterday, my junior called them up. আজকে কি তারিখ হয়? কালি দিছো।
Ajara PS.
এই দুখন দি দিয়ক কোৰ্টক এই দুখন এখন পাইছে কোৰ্টে
Who? Miss Vivian has submitted a letter dated 6/1/26 issued by
অফিচাৰ ইন চাৰ্জ আজাৰা PS মোক কপি এটা দিয়ক
Officer in charge, Azara Police Station, stating that notice has been served upon the respondent number 2. Accordingly, notice deemed to be served upon the respondent number.
কপি পাইছে না অবজেকশন we have filed an objection also
Item
10
10, no? As DCR has arrived, registry to prepare the paperwork. That's all. Then in the IA, right? Ms. B. Boyan submits that written objection has been filed.
yes
It's not there. Huh?
Naipo copy has been served on them
Maybe copy
Not
served,
well.
but yeah. It's not been here, it's not here.
15 minutes before they
Huh?
filed.
Oh, 15 minutes before.
Oh, yeah, my office records
People
is not
submits
well.
that written objection has been prepared and will be filed within
Course of the day.
the course of the day. List the matter. Give it. Same date. Same date, huh?
In this case, a notice was issued. The petitioner was convicted under section 6 of the POCSO.
Only by appears. Only appears. Hey,
What is that?
you say anything? I'm not saying anything.
What about R2?
Lordship, may I know the name of the counsel who appeared on the last occasion?
Last occasion.
SH Bora.
The POCSO, this is a 376 AB.
No.
At,
P7PC.
right? As TCR has arrived, registry to prepare the paperwork. Then yes, R2,
We'll do the need.
people here, submits that she will obtain instructions with regard to whether notice has been served upon the respondent number 2 by the next day. List the matter on, give it. And Ms. Bibuyan is granted 4 weeks time to file written objection to the application under section 430 BNS. List the matter, same date, 12 March. Yes, any objection, 620 days.
No, Lordship. Maybe condone. It will do steps night.
Heard Mr. A. Jahid, learned counsel for the applicant who submits that there is a delay of 620 days
Yes, office.
in filing the appeal against the conviction of the appellant under section 6 of the POCSO Act. Ms. B. Boyan, learned APP, submits that she has got no objection to the delay being condoned. When we are the above, the delay of 620 days condoned. Registry to release the release the appeal. And I, under section 430 BNSS, I is accordingly allowed and disposed of.
Lordship, we have filed an objection. Copy has been served in the IA in advance.
Okay, so what? No one's going to read it. Actually, there's no point.
Lordship. Appeal has not been numbered yet.
No, not number.
Basis of court is at market.
Now it's going to be numbered only.
Yes. Medical report isn't it? Yes, medical report दिया हमारे फाइल का था क्या? Yeah, medical report was called for, right?
Yes.
In.
Medical report.
Lordship, we got a medical report in case of Ramjul Hussain. Paisa na? Oh, someone. Eyewitnesses.
You can start.
Yes. Your Lordship kindly see the FIR lodged by the informant. Your Lordship, page 4 FIR which has been filed by
Yes, let us read page 4. What does it say?
page number 4, my lord, paper book. Informant Mohammed Aizer Haq, son of so and so, name and address of the accused, Mukul Sheikh, son of so and so, Mohammed Hamida Khatun, number 2. Sir, humble submission is that around 3:30 p.m. on 25/6/17, a cow of my nephew, Muhammad Mujidur Rahman, tore the texture and entered the vegetable garden of the aforementioned accused person. Later, the accused person caught the cow and taking it to their house. They kept it tied there. When my nephew, Muhammad Mujidur Rahman, was on his way to bring the cow, accused number 1, with the help of accused number 2, intercepted my nephew on the PW road near their house and hacked him on the neck with a bogey down. And as a result, his head got severed from his body. Blows were dealt on various parts of my nephew's body with dowel, and thereafter, trace of my nephew's body was cut and taken away. My nephew died on the spot. Later, the neighbors and I informed the in charge of the Kalapani outpost about the incident and handed the dead body over to him. I therefore pray you to take necessary action upon investigating the matter and oblige. Therefore, your Lordship kindly see the SR has been written as per version of the informant and it has been read over to him. Upon finding it to be as per his version, he put his signature on it and thereafter I put my signature on the SR. Therefore, the FIR was sent to the OC Mankasar, your Lordship kindly received the SR.
No, Mr. Counsel, if you read every line,
Yes,
so we'll
my
never
lord.
finish this
My
case.
lord.
Yes, how many?
FIR was sent to the OC
Huh?
on 26, my lord, and which was registered on 27, my lord. The FIR was registered by Officer in charge Mankasar Police Station on 27/6/17, my lord. After 2 days, my lord. There was a delay of 2 days delay. This
But
is the
the
case
FIR
under
was-
section 302, my lord. The FIR was lodged after 1 day. Incident was
So what?
happened. Incident
what?
was happened on 25th
So
of,
what?
my lord.
The problem is you are hearing only yourself.
Yes, my lord.
You please hear us also.
Yes, my lord. So this is due to the unexplained. There was no explanation for delay, my lord. There was no explanation for delay. Unexplained delay fatal to the prosecution,
Okay.
my lord.
Any
So-
judgment? Any judgment?
Yes, my lord.
You cannot be in a hurry. You have to be patient. With the speed he is going, it will take some time.
Judgment. Is that I rely upon the judgment passed by our Honorable High Court, my lord. Your Lordship kindly see
Yes.
there are 9, 10, 11, and 15 matters. May I read, my lord?
Read which para?
There are 9, page 17. There are 9, my lord.
Para 9 only.
Yes, there are 9, 10. There are 9, 10, 11, and 12, and 15, my lord.
No, not so many. You cannot read everything.
Yes.
You cannot read everything under the sun.
There are 9 and 10, my lord. On stern scrutiny, we find that there are lots of incontestable discrepancies in the evidence. PW1 in the FIR does not make mention of the presence of PW2 and PW3.
Mr. Counsel, this is regarding discrepancy, not about delayed FIR.
Yes, my lord. The FIR, due to delay in filing the FIR, my lord, this
Yes,
gets
that-
the
Mr.
Honorable High Court,
This para 9,
para 9 and 10, my lord.
para 10
Right.
does not talk of
Yes,
or
ma'am.
speak of
Yes,
delay in filing an FIR.
yes, ma'am.
While the point that they are trying to make
Yes, ma'am.
is that delay in filing an FIR is fatal to the prosecution.
Yeah.
It's like this. You are saying that chicken tikka is very good.
Yes, ma'am.
Okay.
Now,
They are showing me pictures of what? They're showing pictures of what is this? Some curd or whatever.
yes, my lord. Your lordship kindly see para 11, my lord. Para 11.
11. 11.
Para 11, my lord. The material facts adduced by the prosecution are very prominent, and there should not have been any divergent version in respect of a prominent fact, and there is no inter-se corroboration. Therefore, we are of the opinion that it is not safe to place the reliance upon the evidence of the prosecution witness. The evidence of PW 1 to 5 shows that
Mr.
they are
Counsel, you want to talk about tandoori chicken, go to the tandoori chicken part. Okay.
Yes.
Now, you want to talk about delay in filing FIR.
yes, madam.
Para 11 does not speak of delay in filing FIR. It come to para 12.
Yes, ma'am.
Come to the 1, 2, 3, 4, 5, fifth line
Yes, ma'am.
on the bottom. Come there. Look at the para 12.
Clear, ma'am. Like in this case, Your Honor, Lordship, in most of the cases we have come across, investigation is murky and sour.
Wasting time, Mr. Counsel.
Yeah.
You are the counsel here or you are a legal aid counsel?
Yes, ma'am.
You are a legal aid counsel.
Private case
Judgment.
You are not understanding.
Yes, কেসটা আপনার লিগেলি রেকর্ড করছেন আপনার প্রাইভেট কেস প্রাইভেট কেস
Yes, this is private case.
Okay, private case.
Private case.
Now, you see, what you are reading has no relevance to what you are trying to project. Okay,
Yes, ma'am.
where we were telling you which line to read, and you're not reading that. When you want to talk about a pen,
Yes.
please talk about a pen in the judgment. What you're reading in the judgment has nothing to do with delay in filing FIR.
Yes, ma'am.
While your cases, the delay in filing FIR is fatal to the prosecution. It has to correlate, Mr. Counsel. Your judgment has to correlate with your submission. There's no point talking of an Alsatian dog and pointing out an elephant to me. There's no correlation.
Now, my lords, the evidence of PW1, your lordship, and we see the evidence of, in this case, my lord, the evidence of PW.
No, just list out what are the issues that you want to bring to the notice of this court. You are challenging your conviction
Yes, ma'am.
under section
302.
302.
Yes.
Now, first question, is there any eyewitness?
Yes, ma'am.
There is eyewitness.
There is 1 and 2, they are saying that they are eyewitness, 1 and 2, your lordship.
So,
PW1 and 2.
what is your case? Is it your case that they are eyewitnesses or not?
There is a contradiction, my lord.
There is contradiction.
Yes, my lord.
So, is it your case that they are not eyewitnesses?
Yes, my lord.
They are not
I
eyewitnesses.
think the case is, FIR was filed by delay, man. No, unexplained delay was
No, the FIR.
No, that is
The
your,
case is of 25/6/2007 and the case was filed on 26.
26.
Next day itself, the incident occurred.
I think you,
earlier in the
25.
evening.
I think you should both speak to each other privately. Give us, give us. your-
Lordship is better to fix the case after
I know,
vacation.
I think we'll fix another date.
Another day. After vacation, then Lordship, I will,
We'll prepare some more.
I'll tell you.
And this way, though, we will not finish this
Lordship.
on the present the parties list the matter. Item?
Yeah, please. Your
The minus, this look.
Yes.
Lordship. Here the Lordship, appellant has been convicted under section 6 of the POCSO Act.